Greeting to all friends. My name is Alex Naong Felix Sitom. For today's presentation, I will be covering the introduction and fact of the case as part of our group assignment. The case we selected is Winston Tang Chun Leong against 7 Autospa Holding Sdn Bhd. This case was heard at the Industrial Court and it focused on an important issue in employment law, which is dismissal from employment. In my part, I will give an overview of Malaysia's employment law, the citation of this case, and explain the key facts that lead to this legal dispute between the employee and the company. These are the members of our group. Introduction. Employment law in Malaysia is mainly governed by two important laws, the Employment Act 1955 and the Industrial Relations Act 1967. In 2023, the Employment Act was amended and expanded to cover all employees, no matter their salary level. This case highlights three main issues: whether there was wrongful dismissal, whether the employer followed the correct procedures, whether the employee was given a chance to defend himself, which relates to natural justice. The method used for this study is doctrinal legal research, meaning we analyze statute, decided cases, and journals. The Employment Act 1955 set out minimum term for workers, such as a leave, notice of termination, and basic benefits. The Industrial Relations Act 1967 deals with disputes between employers and employees. One very important section in Section 20 of Industrial Relations Act, which allow employees to challenge unfair dismissal at the Industrial Court. 1 January 2023, the Employment Act was expanded to apply to all employees, regardless of their salary. This means that every worker in Malaysia is now protected by the Act. At the same time, this also places greater responsibility on employers. If an employer wants to terminate an employee, they must follow the correct legal procedures. If they fail to do so, the termination may be ruled unfair by the court. The case we are discussing today took place after this amendment, which make it highly relevant. There are three main highlights in this case. First, whether the employee was dismissed without just cause or excuse, which is wrongful dismissal. Second, whether the employer follow procedural fairness, meaning proper notice, inquiry, and communications. And third, whether the principle of natural justice was respected, where the employee must be given a fair chance to defend himself before being terminated. These are the three key issues that the Industrial Court examined when deciding the case. The research method used in this assignment is doctrinal legal research. This is a library-based method where we examine statute, court cases, and legal journals. Through this method, we can better understand how the Industrial Court applies the law to real disputes, such as in these cases between Winston and 7 Autospa. Citation of the case. The case is officially cited as Winston Tang Chun Leong against 7 Autospa Holdings Sdn Bhd. It was reported in the Industrial Law Journal 2025 at page 1081 with the case number 7/41362/23. This case was heard at the Industrial Court in Kuala Lumpur by Chairwoman Puan Vanitamani Sivalingam. From this slide, we can see the fact of the case. To summarize the fact, Winston was hired, later promoted, but then on 15 January 2023, he was verbally dismissed by his manager without any official termination letter. Afterward, he tried to get clarification, first by sending an email, then later through his lawyer. But the company denied that he was dismissed. Instead, the company accused him of insubordination and abandonment of work. Finally, after reviewing the evidence, the court ruled that the dismissal had indeed taken place and it was unjust. Winston joined the company on 10 January 2022 as head of Tinted. Later, in August 2022, he was promoted to executive director. An executive director, his responsibilities were largest. He had to manage operations and supervise other staff members. This shows that Winston was not just an ordinary employee, but someone who held a key position in the company. On 15 January 2023, Winston received a phone call from his manager, Andy. During the call, Andy told him directly not to return to work from the next day onward. What is important to note is that there was no official termination letter issued. Everything was only told verbally over the phone. This became a crucial fact in the case because the dismissal was not properly documented. After receiving the phone call, Winston tried to clarify his situation. On 17 January, he sent an email to the company, but no reply was given. On 27 January, his lawyer issued a letter of demand. On 3 February, the company responded, but they denied that any dismissal had taken place. Because of this, Winston decided to file a representation under Section 20 of the Industrial Relations Act 1967, claiming that he had been unfairly dismissed. In its defense, the company argued that Winston abandoned his job. They claimed he was absent on 14 and 15 January, applied for 11 days of Chinese New Year leave but was only given 3, requested a salary advance which was rejected, and even arranged for someone else to punch his attendance card. However, the court found this claim inconsistent. Being absent for 2 days does not prove abandonment of work. The court confirmed that an oral dismissal had indeed taken place. Since the company failed to prove just cause, the court ruled the dismissal was unjust. This case shows the importance of employers following proper legal procedure when dismissing employees. If they fail to do so, the dismissal can be ruled unfair and the employee will be entitled to remedies such as compensation. That's end my part of the presentation. I will now hand over to my teammate who will continue with the issues and judgment of the case.
So, in this case, there are three main issues that the court had to look at. First, whether the dismissal was done with just cause and excuse. Once an employee is dismissed, it's the employer's duty to prove that the dismissal was justified. Second, whether there was constructive dismissal. This means that the court had to see if the employer's conduct was so serious that it actually forced the employee to resign or amounted to termination. And third, whether there was abandonment of employment. In other words, did the employee's absence really amount to desertion or not? Now let's look at the judgment. The court confirmed that the verbal dismissal of the employee was unjust. The employer also failed to prove that the employee had abandoned his job. So, the court decided that the dismissal was without just cause or excuse. For the remedy, the court awarded 62,300 ringgit Malaysia as compensation plus 24 months of back wages but with a 30% deduction.
Hello, I'm Lau Yok Lian. Now this is my turn to present the PPT. In my part, I will focus on the related topics and laws connected to this case. We are looking at three main topics: the significance of formal letters and notices, the importance of procedural fairness, and the burden of proof of dismissal disputed. Alongside this, I will also explain the main law that apply, which are the Employment Act 1955, the Industrial Relations Act 1967, and the Industrial Court Rules of 1967. These issues are very important because they decided whether a termination is lawful or unlawful. If an employer ignores procedure or fails to follow the law, it can weaken their case in front of the industrial court. So let us look at each part more closely. One of these first topic in this case is the absence of proper formal letter and notices. Under employment law, an employer cannot just dismiss or punish a worker verbally. All disciplinary action, suspension or termination must be put in writing. This ensures transparency, it gives the employee the opportunity to respond, and it protects fairness in the workplace. In this case, the employer failed to follow this basic step. For example, Mr. Andy only told the claimant verbally not to report to work on 15 January 2023. No written termination letter was given. Later, the company only responded after the claimant's lawyer sent a demand letter, which shows poor communication. And finally, when the company accused the employee of abandoning work, no warning letter was issued. All these missing documents clearly weakens the employer's legal standing. Without written evidence, the company cannot prove that it acted fairly or according to law. The second topic is procedural fairness. This principle means that every employee must be given a fair chance to be heard before any action is taken. An employer should not rush into termination. Instead, the correct steps are issue a show cause letter, give the employee the opportunity to explain, and if necessary, suspend the worker while conducting an inquiry. If an employer ignores these steps, it becomes a violation of natural justice. Natural justice is the idea that decisions must be made fairly, without bias, and with respect for the rights of both parties. In this case, because the company dismisses the worker without giving him this opportunity, it shows that procedural fairness was not followed. This makes the termination unlawful. The third topic is the burden of proof. In dismissal cases, the law is very clear about who must prove what. First, the employee must prove that a dismissal actually took place. Once that is shown, the responsibility shifts to the employer. The employer must then prove that the dismissal was justified and based on just cause or excuse. This means the employer must provide documentary evidence such as letters, notices, or proper records, as well as reliable witness testimony. If the employer only makes verbal claims or relies on unsubstantiated accusations, it will not be enough. In this case, because the company did not have the proper documents or procedure, it becomes very difficult or then to prove that the dismissal was lawful. Now let us look at the first law, the Employment Act 1955. This law covers important rules about termination of employment. Section 12 requires proper notices period. The notice length depends on how long the employee was worked. 4 weeks if less than 2 years, 6 weeks if between 2 and 5 years, and 8 weeks is more than 5 years. Section 13 allows termination without notices and only if the other party is compensated with indemnity. Section 14 says that if there is misconduct, the employer can only dismiss after a proper domestic inquiry is held. Section 14 also allows suspension but only up to 2 weeks and with at least half salary paid. Section 15 states that if an employee is absent for more than 2 days without permission or a valid reason, it may be considered a breach of contract, so the action is clear termination cannot be done suddenly or unfairly. Procedures and notice period must be followed. Finally, let us consider the Industrial Relations Act 1967 and the Industrial Court Rules of 1967. Section 20 of the Industrial Relations Act allows any employee who believes there were dismissals without just cause or excuse to file a representation with the Director General. If the matter cannot be solved, it will be referred to the Industrial Court. The court has the power to order reinstatement or compensation. Importantly, Section 30 tells the court to act according to equity, good conscience, and the substantial merit of the case, not just strict technicalities. This means the court look at the fairness and justice, not only paperwork. The Industrial Court Rules of 1967 set out how cases are managed. They will make sure both parties have equal chances to present documents, give evidence, and make argument. These rules to help maintain justice by ensuring that cases are handled in an organized and fair way. So in this case, these law and rules together provide strong protection for employees who face unfair dismissal. They remind employers that any action must be transparent, justified, and in line with proper legal procedure. In conclusion, we see that the absence of formal letters, the violation of procedural fairness, and the failure to meet the burden of proof all point to weaknesses in an employer's case. The Employment Act 1955, the Industrial Relations Act 1967, and the Industrial Court Rules of 1967 set very clear standards for fairness, transparency, and due process. Employers who fail to follow these rules will face legal consequences. That's all for my presentation. Now I will pass the presentation to Mr. Haika. Thank you.
Hello, my name is Haikal and I will show you my presentation today. In this paragraph, we can see 7.0 related cases, which is just refer to several important cases, like Vincent situation. The first related case is 7.1 Wo Che Hong versus Cartel Organization. The main issue is worker claim to have been fired without reason. Well, employers say the worker resigned on their own. Meanwhile, the employer argued that he had resigned voluntarily. The question is, the termination has actually occurred or not? In this paragraph, we can see the result of judgment. The court say dismissal includes constructive dismissal. And second, the burden of proof lies with the employer to demonstrate a reasonable cause as the employer as dismisses the employee without a valid reason. In this paragraph, we can see the comparison of this case. First is both case question whether a dismissal actually occurred. For Wo Che Hong, the employer said he resigned, but Winston Tan said the employer said he voluntarily left the job. In both cases, the employer action need to be evaluated, not just rushed. And once the dismissal is proven, the employer must provide the justification. And 7.2 Wong Yun Hock versus Shaikat Hong Leong is second case. The issue is the worker claim constructive dismissal, and the employer action of not doing the work cannot continue. The result of judgment is the court say dismissal can occur without an official letter. Also, the court say if the employer action violate the term of the contract, dismissal is valid. The Court of Appeal emphasizes that dismissal can occur without an official termination letter if the employer action amount to a fundamental breach of contract that undermines mutual trust. The comparison in our second case is Wong Yun Hock. the employer action can loss of trust. The comparison in our second case is Ong Yo-ho. The employer action can loss of trust compared to Winston Stan, which is verbal dismissal over the phone. In both cases, the actual circumstances are important. In burden of proof, the employer must prove a fair reason or their action is unlawful. In a nutshell, substantive fairness, not formality. And the last one, 7.3, Gon Kyu Poi versus JNP Codes. Employees were dismissed. The issue is whether it was justified or not. The judgment in court say, after the dismissal is proven, the employer must provide a fair reason. The issue is whether it was justified or not. If they are failed, the dismissal is considered unfair. Gon Kyu Poi can claim his right to justice. For comparison in this case, both cases focus on the justification of dismissal. But for Gon Kyu Poi, the employer must prove a fair reason and cannot make hasty decision because it can harm someone. The same as Winston Tan using the same principle like Gon Kyu Poi, which is the burden of proof lies with the employer. Substantive justice is more important than procedure. The impact is the Gon Kyu Poi doctrine has become the foundation of Malaysian labour law, which provide benefit justice in Malaysia.
Assalamualaikum, good evening. I'm from the group 1. Today I'm going to talk about the conclusions. So for this assignment from my group assignments, this case is demonstrates importance of employment right awareness because it's related to the breach of contract and then also the misconduct by employee minor compared to employer procedure failure and the burden of proof favor claimant and evidential weight strong. For these cases, as a result, the court awarded equitable monetary compensations. And then for the next is the reference. So basically, for this, for the law and also for the case law that we use for the assignment, basically we take a few reference. For example, we take from the book. You can see from here a particular approach to Malaysia employment law. And then we also take the book from Industrial Relation of Employment Law. Not only that, we also have the journal. We also take from the journal a few journal that because for this assignment for this group, we are doing a deep research. So basically, we need to use a lot of resources, a lot of reference, not only book, but we use a journal and also the online sources. So these are a few journal that we use for this assignment. And then, like I said again just now, the online sources. For this assignment, we didn't use any ChatGPT because some of the case or the law that ChatGPT give it to us is something is like not even exist. So we cannot trust in that resources. So we use the online sources. For example, we go to the e-law website. We take a few cases from the e-law website. Yes, this one e-law website. For example, the Employment Act 1955, and then also the Industrial Relation Act 1967. There are a few reference or a few act that we use for this assignment. And then for this assignment, we also have a few case law. If you can see from here is a Winston Tang Chung Leong verse 7 Autospa Hollins and Berhide 2025. So basically, these cases happen in industrial court Malaysia because it's related the employee and also the employers. It's about the termination, yes. And then the second one is the Wong Chong Hoi versus Cathy Organization, Sedan Berhad. This case happened in 1988. And then also we has a few here, Telkom Malaysia Kawasan Utara versus Krishnan Kudni Saguni Enor 2002. So there's a few case law that we apply for this assignment. So that's all for today. That because today I represent my group, the group one, for conclusion and also the reference. So that's all for my presentation today. Thank you.